Good afternoon. It's 6 o'clock on a Thursday, and if I'm wearing this suit swimming in a Shark Tank, it's time for my deep divorce deep dive webinar series. My name is Steven Leskin. I am a divorce lawyer and mediator in Portland, and I do these webinars, seminars twice a month. And I take one topic, one divorce topic, and I spend almost an hour talking about it. And tonight's topic is spousal support. And so we're going to go into what the statute requires, how somebody gets spousal support, when it terminates, and we'll go through all of that in depth. So, as usual, as I always start out by saying, I won't take questions during the webinar, but I'm happy to take a question or a call afterwards. You can reach me through my website, www.leskinlaw.com, and get my contact information there. Just tell me you were on the website, on the webinar, and I'll be happy to spend time with you and work through whatever the issue is you want to review. The other thing I would say is that this website will be posted to my YouTube channel and my website probably in the next couple of days. So if you want to review it or refer it on, that's where you would find it. So let's begin. Getting into it, we are going to talk about the three different types of spousal support that the legislature has created for people who are going through a divorce. We're going to talk about proving a spousal support case, and then finally, we'll talk about modification and termination. And that should round out the discussion pretty well. As I said, this is intended to be a deep dive, and I'm not, this is my talking about my experience with these issues for the last 25, 30 years. So it's not intended as like an infomercial for me. It's really my attempt to give both professionals and the general public information relevant to a divorcing couple. A little bit about me. I was admitted to practice law in Oregon in 1992. I opened my law practice the day I got sworn into practice law on September 18th, 1992. I've been practicing family law since 2001. And after I came back from break in my employment, I started practicing family law exclusively. So for about the last 6 years or so now, I've been doing nothing but family law. And within the last couple of years, I've been doing focused more on mediation and my one-day divorce mediation process. All right, so let's get into it. Let's talk about start with an overview of what spousal support is and what it isn't. All right, so spousal support is intended as support for a divorcing spouse. In any divorce, there's going to be really just three issues: division of the property and debt, taking care of the kids, and allocation of future income. And so that allocation of future income is spousal support. And we're going to spend quite a bit of time talking about the three different bases for receiving spousal support. And they're each very different and each accomplish different purposes. And so the baseline, though, is allocating future income of the marriage. I would just also start out by saying spousal support and alimony are the same thing. Alimony is the old term for spousal support. I don't actually thinking about it now. I don't know where the word alimony comes from, or actually why spousal support changed. Maybe it has some additional meaning that's just not appropriate for our times, and that caused it to change. You've also heard of child support, and so let's get into the differences between child support and spousal support. The first and the biggest difference is that child support is not a negotiated amount. Spousal support is a negotiated amount. Child support is set by statute, and if a couple has a child and child support is going to be paid, uh, you can go to the um, Oregon Department of Justice website and you'll find the child support calculator, and that calculator reflects what the statute provides will be child support, right? You may negotiate over the inputs. You may say, well, it's not appropriate to pay uh, child support in these circumstances, but it's going to be the process of arriving at that answer of how much child support will be paid. Uh, that's not up for negotiation. The statute tells you how much child support will be paid. It also tells you the duration of child support. The and We'll come into duration. We'll talk about duration in a bit for spousal support, but child support goes until the child is 18 or 21 if the child's attending school. The duration of spousal support is like the amount, it's also a negotiated amount. So, spousal support amount and duration are negotiated. Child support, the amount is set by statute, as is the duration. So those are the two big differences, and they're important to understand uh, um, what the difference, why there are those differences and what they mean. Um, but the bottom line is, spousal support in a divorce context is it's an agreed amount, an agreed duration, or it's court imposed. Uh, but child support is not. Child support is set by statute for both the duration and the amount. Duration of spousal support. There is a rule. It's not even a rule. It's kind of a guideline, and it's a very weak guideline that the correct amount of the guideline kind of general amount of spousal support is half the length of the marriage, and that kind of works. A lot of people accept that. I'm here to say that that's um, not fully accurate. That's not what judges do. The factors that may go into creating a duration amount could vary depending on income and health and employment and opportunity. So, duration, uh, there's no set way of figuring out how long spousal support will last. It's a matter of either negotiation or the judge imposing it on the parties. In addition to a duration, there's also an indefinite duration, and uh, uh, indefinite awards are rare, but usually the thinking was that 10-year marriage would resolve in to an indefinite award, and that's not true. It's usually, in my experience, it's usually people who've been married 20 years or longer later in life. And that's important. How old the couple is and their health and ability to generate income uh, will go into a factor of an indefinite award. So usually a couple where an indefinite award is made is going to be older and there's less financial opportunity and their finances are set, or there's a disabling condition that prohibits or restricts um, someone from earning money. Uh, a couple could be younger, like in their 40s, say, and one of the parties may have a disabling condition evidenced by the receipt of Social Security disability that would get them an indefinite award. But it's got to be something dramatic like that, particularly for like a younger person. Amount. So, question here is how is the amount calculated? And the amount of spousal support is a function of the difference in income between the two parties. So if somebody is making $10,000, well, let's use a round number. Somebody's using $9,000. Husband is making 9,000 and wife is making 3,000. There's a $6,000 difference. Uh, Spousal support will be some percentage of that 6,000, and it can go from my own research says it can go from 10% to 50 or 60%, right? So and that percentage, if you use that formula, the difference between the incomes, uh, that that range, that percentage will vary county by county. It will vary judge by judge, and there's a tremendous amount of range in what judges will award. And remember, we're only talking about where judges award now. So the amount of, I'm just going to say this one more time. The amount of spousal support is a function of the difference between the two partners' uh, income, and it will be some percentage of that number, and that percentage can range from 20, 25, 30, 35, 40%, uh, as just a working number. Uh, but again, like I'm trying to emphasize, that number is not set in stone. It's a negotiated amount, or it's an amount that's going to be imposed by the court after trial. Some other issues that come up along these lines are, what if a spouse is refused to work or hasn't worked? How will the judge attribute um, income to that party? So suppose that husband has, well, let's say wife. Let's say wife has a PhD and the potential to earn. Let's make it interesting. Let's say wife has a PhD in computer science, in some aspect of computer science or AI, and has the potential to make three or $400,000 a year, and hasn't worked, hasn't wanted to work, hasn't applied herself, and husband is a makes 100, let's just pick around number, $100,000. It's a long marriage, and husband believes that he's entitled to spousal support, and wife has not been really active in her career. She's refused to work. She's trying to maybe she's got it in the back of her mind that she doesn't want to pay spousal support, so she's trying to create a lower earning record. How will the court view that? And so, what parties will do is they'll bring in an expert to say a person of this qualification can earn, um, this much money. Uh, the other thing that people will do is they'll look at the Social Security disability earning record, which shows reported income and is considered authoritative. And they may look at that and say, well, in these years, you were hitting that $400,000 mark. And then, when the marriage started going south or whatever, you started bringing in 150. So your earning capability is really closer to 400 than the 150 that you reported for the last couple of years. And so courts will consider that too. The statute doesn't really allow that, but the statute allows that for child support. You can't shortchange your child by not working and driving down your income numbers. The statute, we're going to talk about at length in just a minute. The ORS statute, ORS 107 105, just talks about income. It doesn't really talk about imputing income, but that's what judges do. A judge won't let somebody show lesser income for spousal support purposes than what they may have historically been making, or what expert comes in and says, a person either in this position or a person with this capability has a potential to earn this. So that's what excuse me. That's what happens when income may not be fully reported, or somebody's trying to shortchange their spouse by not working up to their potential. I think that covers that discussion about how amount is calculated, agreed to, and how what happens when somebody's maybe like working under the table or is not working to their full potential. I'll come back to that working under the table. I hadn't really considered it when I was putting the deck together. Uh, every now and then somebody will come into the office and say, my spouse is it works for themselves and they're not generating, they're not showing any income. It's all under the table, or they're working for somebody who's under the table. And um, an attorney has the resources to um, subpoena the employer, subpoena bank records, and put um, the cheating partner under oath and take the deposition. It's usually a lot of money to do that, and so people don't. I haven't really done that often, but there's certainly been times when I've had to account for somebody working on the table, not reporting income over years, and the attorney has to do some math to figure out whether or not it's worth it to pursue that fees versus what the potential return is. But those are the options too for a spouse who uh, someone suspects is not showing their full income for spousal support or child support purposes. All right, so let's change gears, and this section is going to be focused on the three types of spousal support and the statute. And so whenever I say, or whenever an attorney says ORS, that's an abbreviation for Oregon Revised Statutes. And it's revised every year, so that's why it's called revised. And the chapter that deals with um, divorce is found at ORS Chapter 107. Chapter 106 deals with marriage, 107 deals with um, divorce, 108 deals with spousal and child relations, and then there's 109, which covers uh, um, children born out of wedlock, children born outside of marriage. So our focus tonight is on Chapter 107, and specifically, the statute is, if you want, you can Google this if you want, just Google ORS 107 105. And that substatute is called provisions of judgment. And that one section of 107 deals with how property and debt and children and uh, spouse support are dealt with in context of um, divorce. There's other particularly with the children. There are many other statutes, but this is what 107, 105 is what the requirements are that have to be in a judgment at minimum. So to get to um, a spouse support award, one of the spouses, and I just gonna say this, either a husband or a spouse, uh, boy, I didn't say that one right, either a husband or a wife may be entitled to spousal support. Culturally and economically, it's usually the wife who's going to have the entitlement to it, but it certainly happens, and it happens more and more. And certainly in my divorce, my mediation practice, I see more and more couples where it's the wife who's been the significant bread earner in the couple, and she may be required to pay spouse support, same as if her husband was the dominant earner. So you should understand by now that spousal support is a function of uh, the amount of spousal support is a function of the two incomes, right? It's based on the discrepancy in income. If two people were earning the same amount, there would be absolutely no basis for a spousal support award. A court would not do that. If both couples were earning, suppose both couples were earning $5,000 or $6,000 a month, a court would not impose spousal support in that circumstance. If one of the couples was earning, let's say one was earning six, the other was earning seven, same thing. There's not enough difference there. Seven, eight, not enough difference there. If somebody was earning 8,000 a month and the other spouse was earning 1,000, regardless of whether the husband or the wife was the earner, that would be a case uh, for spouse support, particularly if it was, a longer marriage. And in this context, longer means anything than 2 years, 3 years. A super short marriage will probably result in just a token payment of spousal support, if any. So, in order to prove the incomes of both parties, the court's going to need to see income tax records. It's going to need to see payroll records, bank statements, brokerage accounts, if dividends are used as part of income. If somebody has investments, whatever documentation there is, and it's probably just going to be in the tax returns, uh, uh, those will come in as evidence of income. So tax returns are probably the best source because they lay out, and there's penalties if you don't declare. Uh, um, uh, what income is. So usually, uh, a couple of years back of tax returns are what is used to determine monthly income for the parties. Uh, Something that I rely on a lot is a Social Security earning report, and that's available by going to the Social Security website and looking up earning report, and then you have to create an account. And I think that they're not. It used to be that you could just have it emailed to you, but I think it's now mailed to your last known address with the Social Security Department, and that shows all of your reported earnings through your life. Uh, Mine goes back to, I don't know, when I was 15 or 16 and started working, and it's not generally accurate. It is, in my experience, it's an accurate report, and is to me is an authoritative record of what somebody has earned over the course of their lifetime. If there are sometimes people say, well, I work on commission and my income goes up and down, or I know I'm going to get terminated from a job. Oftentimes what the courts will do is they will look at the Social Security earning record or back taxes and say, well, for the last 3 years or for the last 4 years, you earned this much on average. So they'll average that. If somebody's had like wild swings in their income, will generally go up, but if somebody's had wild swings up and down, the courts will say, okay, we'll just average that over so many years. Every judge is different. I don't know that there's certainly no rule that says you have to go back 3 years. Personally, if I'm trying to calculate it, I'll go back uh, the three prior years. If I'm advising a client or in a mediation, I'll advise that 3 years is a good amount to go back to get some um, baseline for how much both parties or one of the parties should be uh, used to calculate their income. Suppose somebody, we talked about this a little bit, but suppose somebody uh, uh, is hiding their records, won't produce their records, hasn't kept records. I've had cases, I have a case now where the husband uh, like just is self-employed and just doesn't keep records. There's no, all there is bank statements, and I don't even trust those. So how would you, and um, their spousal support is an issue. So how would you go about um, showing what husband's income is in the absence of records? So there's two or three different ways. One is you can hire a business broker, and a business broker can come in and say, on average, um, I've looked at the business on what I could find. A small business like this or mid-sized business like this would it's going to be a small business. It's not going to be a mid-sized business. A small business like this would generate this much in sales and profit, and therefore the business has a value of X, Y, and Z, and therefore we can figure out that the monthly income is going to be so much. You could also hire a vocational expert who will say that a person who has this is two, a vocational expert can come in and say, well, generally people who engage in this type of industry earn this much. And that's going to be a little bit higher than owning your own business. Uh, uh, but that's another way of proving what somebody's full-time monthly salary would be. Either broker or an economist. Economists can also do the same kind of analysis, uh, or going slightly different and hiring a Vogue person to say, well, generally in the area where this person is working, similarly employed people earn X number of dollars a month. Um, so that's how you would determine when somebody is hiding or just not keeping records of their income. And again, I'm just going to touch on this really briefly. If income is believed to be hidden, an attorney has the power to subpoena bank records, sit somebody down under oath at a deposition, uh, and that person could be the spouse, it could be an employer, um, and start to get at the truth that way. If it's under oath, then there's the penalty of perjury if somebody later is discovered to have been lying to continue to hide their income. Okay, so now we're going to get into the three types of spousal support, and this is really the meat of what we're talking about tonight. And so I want to start with, remember what I said at the beginning, that there's three types of spousal support. There's compensatory support, which we can talk about now. There's transitional support, and then we talk about maintenance. And that kind of runs in order of reverse popularity. You do not see too many compensatory support cases. So compensatory support um, is appropriate in a situation where one spouse has contributed to the education or professional development of another spouse. So, for example, the classic situation is uh, wife goes to medical school for 12 years, incurs a huge amount of debt, and husband's been supporting her through all of those years. And the day she walks across that stage and is given the diploma, says adios, thanks for the love. Uh, that husband has bought into her career and her future earnings, and that is compensatory support. So uh, um, it's it can be used in conjunction with maintenance support or transitional support. You can get a separate award for compensatory support, uh, um, but uh, it's compensatory, right? You bought into that person's future earnings. You sacrificed for that person to have a better life, and it doesn't matter who initiates the divorce, of course, uh, but compensatory support is available in those circumstances. The legislature has laid out principles for the court to look at um, when making an award of compensatory support, and we'll just go through that. So, uh, not surprisingly, um, the factors to be determined are the amount of money how much money was spent to support the spouse, the duration and nature of that contribution. So somebody paid all the household expenses over the course of 12 years for medical school. They paid for vacations, they paid for kids. So that all comes into it. The duration of the marriage. Uh, if the couple was married for the entire amount of um, uh, uh, the if the marriage lasted before and during um, uh, medical school, that will um, determine how long the compensatory support award will last. I'm happy to answer. Somebody raised their hand. Uh, I see. Um, I will answer questions like offline. I'm happy to answer questions offline. You can see that I kind of got a little distracted now. Um, but just hold your questions and we can talk about them later. And I'm more than happy to do it. It's just I'm the only one here, and it's just too distracting to come back to questions. Um, the relative earning capacity of the parties. One of the parties is going to have, in compensatory support, one of the parties is going to have a higher income, right? Uh, uh, and so um, the amount of that higher income is going to also contribute to the amount of the award for compensatory support. Uh, the extent to which the marital estate has already benefited from the contribution. Um, that means how long after the like medical school ended was the divorce filed. So like maybe they had a great lifestyle for a couple of years afterwards, and then or later in life. So that's going to diminish somewhat because both parties benefited from it. The tax consequences to each party, that's no longer relevant. The Oregon statute hasn't caught up with federal law. In the first Trump administration's, the tax consequences of spousal support to both parties was eliminated. So there's not going to be tax consequences for the support, even though that particular criteria is going to come up again and again. The other thing that I would point out is that the compensatory spouse support um, is just and equitable in all the circumstances. That's you can see that in the statute, and that tells the judge that's code for the judge has uh, discretion. It's a discretionary amount, and that's important because unless the judge is like way out of line, um, uh, an appeals court is not going to disturb a discretionary award, right? So that's just and equitable. It's presumed that, well, it's not presumed. That's the obligation that the judge has, but it's a discretionary, it's saying to the court, to the trial court, um, your award is discretionary. There's no formula here. You just have to keep it within. If you don't apply these criteria correctly, that's one thing. If you don't apply the legal standard correctly, that's one thing. But if you apply the legal standard correctly, your decision will stand. Transitional support. So, transitional support is appropriate where someone has been a homemaker for years and needs to transition back into the workforce. So, mom stayed home raising the kids, and maybe mom was doing social media marketing, or better yet, accounting. And there's been so many changes in the accounting world from when she was doing bookkeeping or accounting, and she now needs to go back to school, come up to speed on the new tools that are available. And so transitional support is designed to help a spouse come up to a position of self sufficiency. And so the evidence for transitional support will be it's going to cost this much to go to college or trade school or whatever it is. It was going to last this long. I'm going to need to buy books. I'm going to need housing. All of those things come into consideration in a transitional support. So transitional support is usually 2, 3, 4 years, and it's that should be enough time for the spouse to um, uh, get their skills up to speed so that they can support themselves and have a comfortable lifestyle or something that's not disproportionate to what they enjoy during the marriage. Again, the legislature is telling the court how to make this decision, and the court is going to look at the duration of the marriage, a party's training and employment skills, uh, um, a party's prior work history, the financial needs and resources of each party, uh, a party's custodial and child support responsibilities, and then any other factor which the court deems just and equitable. Right. So a court may award transitional support to help a party get back on their feet. And then finally, maintenance. A maintenance award is appropriate where the couple is probably going to be older and they've been married for a long time, and now uh, this is usually applied to wife. Wife hasn't worked, and she's entitled. The courts, we as a society are not going to turn her out when she gets divorced. That used to be the case, but we've grown as a culture and as a judiciary, that she or he, but mostly in this case she, uh, still has the right to enjoy a standard of living not disproportionate to what she enjoyed during the marriage. Uh, um, so, spousal support ensures that a spouse in a long-term marriage who may not has worked or has ability to work or has resources, um, uh, is not impoverished, but continues to maintain a lifestyle similar to what she enjoyed during the marriage. Um, the statute specifically says that um, an award of maintenance can be indefinite or for a limited time. And then it runs through the uh, uh, factors again. So the duration of the marriage, the age of the parties, the health of the parties, the standard of living established during the marriage, um, and then the relative earning income and earning capacity of the parties, recognizing that the wage earner's continuing income may be a basis for support, distinct from the income um, from marital property. So this is anticipating an older couple that may have retirement accounts or may have rent coming in or a portfolio. And so their earning could come from uh, that uh, box of bin of money or whatever that or from employment. And so both of those are taken into account when considering a maintenance award. The financial needs and resources of each party we've talked about, uh, and then also custodial and child support responsibility still comes into play here, even though it's less likely here than it would be for um, uh, transitional award, um, because the kids are going to be older at this point when maintenance is awarded. So those are the three types of spousal support that are available. Uh, Spousal support can a judge can award uh, two types of spousal award. So a lot of times you'll see maintenance for maybe a long period of time, and then a transitional award to help a spouse get back up on his or her feet. Spousal support, um, transitional support, oftentimes will graduate down. It doesn't graduate up. It graduates down as it's anticipated that the spouse is earning more money. Um, if the testimony is that um, the spouse, suppose that the spousal support award is $3,000 a month, but it's also anticipated that um, the spouse is going to go back to school and then start earning, uh, then the maintenance award also may decrease over time. It could also go up. Court could find that like maybe there's health issues that are going to result in greater expenses and greater need, and so the court may uh, step up a spouse support award, but generally the spouse support will go down. It'll either stay equal or even, or it will go down over time. And so, uh, not often, but it's not unusual for the court to award like a baseline maintenance and transitional support. So um, that covers getting spousal support and the factors that a couple will look to either um, make their spousal support to argue the court that they're entitled to receive it, or argue the court that they ought not to have to pay for spousal support. So um, we're going to talk now about term of termination and modification of spousal support awards. Spousal support is automatically terminated on the death of a party. And every judgment you ever read will say, every divorce decree will say, spousal support terminates on the death of the party. If there are arrearages, somebody didn't pay their spousal support, the receiving spouse can still go after the estate of the other party for arrearages, but the award of spouse support terminates on the death of either party. Some other um, uh, factors where a judgment may be modified, and maybe the modification is to zero, include marriage. So the receiving spouse support now has more income in the household, and that's considered a change of circumstance sufficient to justify modifying the spouse support award, and the modification may be to zero. Change of circumstance may also include, you have to prove that there's been a significant change of circumstance since the judgment was issued. And that that change of circumstances include remarriage, loss, profound loss of employment. So if somebody's been out of work for an extended period of time, that may be considered a change of circumstance. A change in the job market, so somebody's skills are no longer uh, 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 generating the same kind of income through work that they once did. That may be a modification. Disability uh, uh, through illness or injury can also be considered a change of circumstances sufficient to either modify or terminate a spousal support award. So that covers it. That's everything I think you probably wanted to know about spousal support. I'm glad to see that there are people still on with me tonight. Again, take my contact information. I will be more than happy to go through questions afterwards, online, in person, whatever, however you want to do it. I know there was at least one question that came up, so I'm more than happy to take the call and work through it with you. I can be found at www.leskinlaw.com. If you've liked this, you know the drill. Please, give me a like on YouTube, or on Meetup, or on Google. Those actually help. Those really actually do help. It gives people another sense of it verifies my legitimacy and helpfulness, and people do read those reviews and things. So thank you for watching, and well, look, the next video is in 2 weeks, and it's on mediation and domestic violence. And that's been broadcast to the mediation community. So there'll be a lot of people in attendance. It should be a very, very interesting um, seminar, something that I have a subspecialty in, and I'm looking forward to giving that one. So thank you very much, and have a good evening. Thank you.